Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall, and my co-host today is James Hunsberger. Hello, James.
Hello, Matthew. Great to see you.
Today's episode is a new era for EU and UK deals, EC's draft merger guidelines, and the CMA's growth approach. We'll be discussing the long-awaited and much-discussed guidelines document published by the European Commission for consultation on 30 April 2026. We'll also compare this with the UK CMA's new approach to merger control, a topic we considered in detail in episode 361 from January 2026.
And our guest today is Stuart Hudson. Stuart is a partner and co-lead of advisory firm Brunswick's global regulatory practice. He previously served at the CMA as Senior Director of Strategy, was a special advisor to former British Prime Minister Gordon Brown, and is a senior fellow at the Social Market Foundation think tank in the UK. Hello, Stuart, and welcome to the show.
Thank you, James and Matthew. I'm a big fan of the podcast, so it's great to join you.
Well, thank you very much for coming on. As listeners will know, the European Commission reviews large M&A deals affecting the EU under the EU merger regulation, the famous EUMR. In 2004, the Commission published guidelines on how it will substantively analyze horizontal or overlap transactions. This was followed by the 2008 guidelines on non-horizontal deals, i.e. those raising potential vertical and conglomerate issues. The new guidelines we'll be considering today replace both of those, or will replace both of those. The consultation is open for comments until 26 June 2026, with the Commission expected to publish the final version in Q4 2026. So Stuart, against that background, could you start us off, please, with an explanation of why the European Commission decided to revisit those two sets of guidelines, and also broadly what the new draft contains?
I think there are three factors at play here. The first is that, what has changed in the economy in the period since those two previous sets of guidelines were introduced back in 2004 and 2008, as you said. We've seen in that time the extraordinary explosion in digital markets, operating across borders, and Antitrust has had to take account of this, looking at, to a greater extent than previously, at non-price factors in competition, at network effects, at issues like killer acquisitions. And so the economics has really moved on quite a bit. But the second factor is that the European Commission hasn't stood still in this time. It has been grappling with these issues in its cases in recent years. And so what that means is that the guidelines as they currently stand don't currently fully reflect the European Commission's decisional practice. So again, you've got good grounds for reviewing the guidelines at this stage. But there's a third element at play here as well, which is the broader political debate in the European Union at the moment on the relationship between competition and industrial policy. Now, in some ways, this is an age-old debate. It comes up every few years, and many listeners of the podcast will remember in 2019, the European Commission's decision to prohibit the Siemens-Alstom merger on the grounds that it would be bad for competition in the markets for railway signalling systems and very high-speed trains. And that prompted a really quite strong negative reaction from the French and German governments in particular, who felt that competition policy risked being a barrier to the development of what is occasionally referred to as European champions that could compete effectively in global markets. And we saw over subsequent years this debate sort of really continuing with a lot of focus on the tech sector and some kind of real angst in a way about why was it that so many of the most valuable tech companies globally have grown in the United States, but not in Europe. And then in 2024, we saw two very important reports. The first from the former Italian Prime Minister, Enrico Letta, on the future of the single market, in which he looked, amongst other things, at the relationship between competition and industrial policy. And then most significantly of all, the report in September 2024 from the former president of the European Central Bank, Mario Draghi, on Europe's future competitiveness. Now, competition wasn't, the main subject of the Draghi report. It wasn't even a particularly sort of substantial part of it, but it did call for a reappraisal of it. And it came at a very significant time. There are different views on the extent to which Draghi influenced the thinking of European Commission President Ursula von der Leyen, or whether von der Leyen influenced what Draghi said in his report. But either way, it had a real impact. And just a matter of weeks after it was published, when Teresa Ribera was appointed as the Commissioner for Competition, amongst some other policy areas, her mission letter from President von der Leyen called for a reappraisal on competition policy. DG Comp then launched this review of the guidelines in 2025. And after some pushing from the President to speed up, the draft guidelines were published then in April of this year. So in terms of what they contain, it probably makes sense to say first what hasn't changed. So the test that the European Commission needs to look at in merger control is still the test of whether there is a significant impediment to effective competition. That hasn't changed in the guidelines, and indeed it can't change because it's set out in the EU merger regulation. The Commission, or certainly DG Comp, would still say that the primary objective here is to maintain effective competition and competitive markets. So again, that hasn't changed. But what we do see in the new consumer guidelines is greater attention to non-price competition issues, such as around sort of innovation, quality, privacy, sustainability, resilience. It gives more attention to dynamic competition as well, so for more forward-looking analysis of how markets may develop over time. And that was a particular concern that the Draghi emphasized in his report. And third, it looks in more detail and is much more open to efficiencies. Now, here, the guidelines do still say that efficiencies have to be verifiable, they have to be kind of merger specific, and they have to benefit consumers. But the language is much more open to dynamic efficiencies, with a greater ability or incentive to innovate or invest over time. And the efficiencies don't necessarily have to be quantified. And in some cases, they may be out of market. They may even be benefiting consumers other than those who might directly be harmed by a transaction. So you've got quite a significant change there. I think in terms of what this then kind of means for companies doing deals and how they articulate their arguments, perhaps the most significant things are probably two. First, scale is no longer a dirty word. Indeed, to the extent that scale can make European companies kind of more competitive, more resilient, it can be a good thing. And companies can articulate the case for why their deal is positive in what the guidelines refer to as a theory of benefit, bringing together kind of all the positive arguments for a transaction. And those, I think, are really some of the most significant changes.
Absolutely, Stuart. And I think it's important to point out, as you say, the theory of benefit is really where the efficiencies arguments are going to be raised. It's a new concept from the Commission. And also just to point out for listeners that the draft guidelines make it clear that this is what the Commission refers to as an overall assessment. So in its overall assessment, it will consider the potentially anti-competitive issues, and therefore whether the efficiencies, they use the word counteract, outweigh in the balancing exercise the anti-competitive factors based on the theory of benefit, as you say.
So, Stuart, you've touched on this a bit in your answer just now about some of the changes, some of what's new. There's been a lot of discussion in the last few weeks about how significant the draft really is, if it's ultimately adopted in this draft form or something similar to it. Some commentators say it's dramatic change. Some say it's largely more of the same. What's your take?
Yes, it was really quite striking the extent to which there was a difference of emphasis also within the Commission here on this. If you look at the comments from President von der Leyen compared with Executive Vice President Ribera, Now, when I first saw the press release, I thought, well, perhaps we shouldn't pay too much attention to that. I mean, having been responsible for many government press releases over the years, I'm quite used to the idea that you will have different quotes from different message carriers, each putting forward particular points you want to get across. But the important thing is to look at the message as a whole. But I think what is significant here is that when each of those individuals has been doing kind of their own sort of separate sort of speeches and media briefings, they've actually kept to their own particular emphasis. I mean, all three of us were at the ABA spring meeting in Washington, where Teresa Rivera really emphasized the importance of maintaining DG Comp's traditional focus on competition, not sort of being subject in particular to external and political kind of influences. Whereas when President von der Leyen has been speaking publicly and in some of the media briefings that have come from her or her cabinet, the emphasis has been more on how much of a break with the past it is. So this creates, I guess, a challenge for practitioners in trying to work out, well, who should we pay more attention to? And I think there are two ways of looking at this. Now, one is actually to look back at previous cases and say, well, actually, if we were to apply the new guidelines to these old cases, would there have been a different outcome? And my Brunswick colleague, Paul Jajar, who was director at DG Comp, who led the case team on the Siemens-Alstom merger, spoke at the ABA spring meeting on the subject of Siemens-Alstom revisited and what would have been the outcome of that case under the new guidelines. And I think he concluded that it's not necessarily a slam dunk that it would have been cleared. There is a chance that it would have got through under the new guidelines, but that would have been dependent on the evidence in the case that the parties sort of put forward to back up their claims about the market, the efficiencies that would result, and probably on putting forward a remedies package that they had not been prepared to put forward last time round. I think the other way of looking at it is also to look at the point that you referred to, Matthew, which is around the balancing that the Commission is being asked to do here. Because when you ask a public body to balance a range of different policy objectives, and when some of those objectives and the benefits associated with them aren't quantifiable, and when you can't necessarily tell which groups of people, which consumers the benefits would accrue to, you are increasing the number of possible outcomes to the case that the Commission could plausibly defend in court. And what that means is you're giving discretion to the Commission. And it's interesting that the guidelines don't hide away from this. In fact, there are, I think, 8 references in the new guidelines to the margin of discretion that the Commission has here. And so that then sort of creates the question, well, how will the Commission exercise this discretion? And will that discretion be exercised primarily within DG Comp or with influence from elsewhere? And I think there are good reasons for thinking that DG Comp will still remain sort of very powerful here. If you look at the officials in DG Comp, they're experts in competition, they're working on these issues full time, and they control the process. Whereas if you look at those elsewhere who might be coming either from the cabinet of President von der Leyen or from the member states or from elsewhere, you've got fewer experts on competition. They're distracted by multiple other issues that they have to deal with, and they don't control the process directly. Now, in any institution, if you've got experts who control the process, they exercise a good deal of power. And so that, I think, should give some, reassurance to DG Comp. But there are also arguments for suggesting that some of this discretion may end up being exercised by people outside DG Comp, and perhaps in particular around sort of President von der Leyen. And here, I think it's quite instructive to look at the minutes of the orientation aid at the College of Commissioners on the subject of the draft merger guidelines that took place on the 18th of March, I think. And there, it's clear that almost every intervention from commissioners, including from the president, was really in favour of the relaxation of the guidelines. And indeed, when President von der Leyen was summing up the discussion at the end, she said, and I quote, "The message must be clear. The world had changed, markets were now global, and European businesses needed predictability." Now, that is not a summary of the overall press release that came from the Commission, and in which Executive Vice President Rivera's comments on the mission for competition featured so strongly, that's quite a steer here. And so I think that what that could suggest is that not routinely, perhaps not even occasionally, but where there are cases where member states and where the president of the Commission does think that European club interests are significantly affected, that they may seek to exercise pressure. And indeed, even when that is not the case, DG Comp is going to have a bit of a balancing exercise itself to work out, where do I need to take the pragmatic judgments here? Does it make sense for me to take into account the policy interests?
Yeah, that's a great analysis, I think. And just a point there, of course, these decisions, point taken on the DG Comp having control of the process and the facts, essentially. But ultimately, these are, of course, European Commission decisions, aren't they, which are taken by the Commission. And I wanted to flag up, again, the margin of discretion point that you mentioned there, Stuart. I think I counted 9 references to discretion, so 8 or 9, I'm not sure which it is, but certainly it does appear in the efficiencies, including at paragraph 342, where the Commission states that where there is substantial consumer harm and benefit, a careful analysis is required. Commission disposes of a margin of discretion. So also it would seem more difficult potentially to challenge in court when the Commission is relying on efficiencies to clear it and using that margin of discretion. So that may, militate in favor of some, clearances of these more, if you like, borderline or tricky deals.
I think that's absolutely correct. And the one point that's probably also worth noting is that the guidelines don't suggest that the discretion will necessarily automatically be exercised in favour of clearing deals, because there are areas where they suggest that the Commission would have the power to take a tougher approach if it thinks necessary. And so in particular, where there's a prospect that a merger could entrench a dominant position. And that, I think, kind of reflects quite closely the Commission's approach in the Booking Neutrality case, which is, of course, before the General Court, and therefore the outcome of that court case will trump whatever is in the final version of the guidelines.
Absolutely, as you say, the margin of discretion operates both ways, and indeed the guidelines do point out a number of theories of harm, including a new entrenchment, quite controversial, I think, entrenchment theory of harm, subject to the court in that case. Stuart, moving on to the UK, I mentioned this in the introduction. We looked at this in a previous episode, but as you well know, the UK has been revising its approach to merger control as well. So could you just remind us in outline what's been going on in the UK before we look at the kind of comparison in a bit more detail?
Yes, so the UK has seen sort of a significant period of change in competition policy, and you could look at it, I think, in sort of 3 phases, really, since the CMA was created in 2013. So there was a period where it was considered and sometimes accused of taking perhaps a too narrow approach and under-enforcing in mergers. And then subsequently, particularly in the periods in which I was at the CMA, serving under Andrea Coscelli and subsequently Sarah Cardell, a period where it did take a much more kind of robust approach. And this was both in where it was asserting jurisdiction, which mergers it was seeking to call in, and then its substantive analysis of the mergers it was reviewing, and also, importantly, the process that it tended to follow and how it was treating merging parties during the course of its reviews. And when the Labour government came in 2024, it found within the first few months that of all the regulators and public bodies for which it was ultimately responsible, the CMA was the one about which ministers were getting the most complaints, and in particular from chief executives of overseas businesses, including particularly from the United States. And since that period, there's been a period of quite significant change at the CMA. This began really with the November 2024 Chatham House speech from Sarah Cardell, setting out a range of process changes at the CMA. In January 2025, the chairman of the CMA, Marcus Bockerink, was removed. In February, a set of some further changes were announced around the processes that the CMA would follow in mergers. And subsequently, we have also seen proposals to change its remedies guidance and also its approach to rivalry enhancing efficiencies. So quite a lot going on with the CMA.
Thank you very much, Stuart. So a question from my perspective as a advisor to clients doing global deals. Deal makers are focused on certainty and predictability. One vector that affects certainty and predictability is the margin of discretion we were just talking about on theories of harm, on benefits that are considered. Another vector is potential divergence across jurisdictions. And that's something that's happened, obviously, in recent times, both within Europe and with other jurisdictions. So could you give us a prediction on whether you think the EC and UK are likely to converge or diverge when it comes to the merger guidelines?
The trend has certainly been towards more convergence. After two significant of deals that the UK CMA prohibited, which had been cleared by the Commission, so that was Cargotec Konecranes and then the first Microsoft Activision transaction. Subsequently, we have seen a fair bit of change, and that was really encouraged partly by the UK government's strategic steer to CMA in May of last year, which encouraged the CMA really to focus on deals where it could have the biggest impact on UK consumers, that where it was looking at international deals, it should take account of what was being done by other authorities so that it could avoid either duplication or incoherence, and that where it identified competition concerns, it should be open to constructive remedies that could address them. And that has certainly, I think, removed quite a lot of the scope for divergence that there was previously. Importantly, though, I don't think it means that business can forget about the CMA or that the CMA itself can actually forget about global deals. And here, I think the recent Getty Shutters case is quite significant, where even if the CMA had wanted, I think as it generally has done, to try and take something of a wait and see approach to international deals, not to get ahead of other authorities, it found in that case that there were issues which would require which would have required Getty then to sell the editorial business. And indeed, the parties had proposed this as a remedy in phase one, hoping to avoid a reference to phase two. The CMA did refer to phase two. At that point, the parties tried to propose a more limited set of remedies in phase two. But I think the fact that they had previously proposed that wider remedy did give the CMA some confidence to actually hold its ground quite firmly in phase two. So I think that tells us a couple of things. First of all, that companies can't forget about the CMA, but also they're going to have to think quite carefully about the strategy, both how you're going to deal with the CMA over time, as well as then the interaction with other agencies.
On this issue, Stuart, and bringing it back to efficiencies, what's your view on, if you have any view on how the Commission's, if you like, new analysis of efficiencies and the CMA's view on this kind of overlap or differ? The CMA talks about, in its guidance, rivalry enhancing efficiencies, which can offset an SLC, and also customer benefits, the RCBs, which can outweigh an SLC. It's kind of classic, perhaps overly complex, UK division. But what's your view on how those two issues from the CMA or UK point of view link or overlap with the guidelines, the Commission's guidelines, and how they consider efficiencies?
And look, I think the CMA's review is still underway, so we will see how that pans out. I think overall, you've got a trend of greater openness to efficiencies that's in both jurisdictions that I think is certainly helpful for deal makers. And indeed, I think for international deals more generally, the positive takeaways that I'd have is that if you compare where we were 2 to 3 years ago in both the EU and the UK and the US, where all three of those jurisdictions were looking pretty aggressive in their approach, all three of them have changed. And not all to the same extent, not all in the same way, but the direction of travel, including but not limited to efficiencies, has been pretty clear.
Good news for our clients. So in light of all these developments, are we seeing a greater risk of politicization in the EC and the UK?
I think it's really important to distinguish between different kinds of what we might refer to as politicization. And I wrote recently on this, and we can perhaps share the link in the show notes. But at one end of the spectrum, there is what we might call some politicization in terms of prioritization. What cases do agencies decide to call in? That's including in mergers, but also or consumer protection cases and market studies and investigations for those agencies that have that power. And we've certainly seen, I think, probably a greater trend for elected governments to have a bit more of a say on which of those cases, which kinds of cases agencies should be looking into. Now, as long as when they do that, elected governments are then happy to step back and allow the agency to come to its own decision and its own findings without interference, I think that's probably, fairly legitimate. And indeed, in some cases, actively quite helpful if it enhances the legitimacy of a competition or authority. I think that's all to the good. We also see areas where politicians are encouraging agencies to pay attention to broader factors, but in a way that is consistent with the focus on competition. And I think an example here would be where President Biden in the US started talking about wanting a pro-worker antitrust. And at first, at a glance, I think that caused a bit of concern because people thought, well, hold on, surely, competition should be about protecting consumers. But when you looked at the kind of things that President Biden was actually proposing, looking at kind of non-compete agreements, looking at kind of licensing agreements that were negative. That sort of thing was actually entirely consistent with pretty standard antitrust analysis. It wasn't trading off competition against another priority. I think where political involvement becomes more problematic is where you are trading competition off against other objectives, be it in terms of industrial policy, sort of sustainability, or so on. And we are seeing this in the guidelines, and we are seeing it in the approach of the UK government. And there, I think there's a question around, well, okay, fair enough. Governments get elected, antitrust authorities aren't. There is a case for that elected governments are better placed to decide between some of these competing policy objectives. How do you go about doing that? And I think it is preferable for that to be done at the overall policy setting level through a general steer all through the guidelines. And then you allow your competition authority to take its decisions independently on the individual cases. Now, I think if we compare the UK and EU approaches at the moment, there's perhaps more of a chance that despite what we might have thought from media coverage over the past year or so, that the CMA may be able to protect its independence in individual decision-making slightly better here. And the reason for that is that I think the UK government has given a slightly clearer policy steer to the CMA on what it wants it to do. And that's on the kind of issues that we talked about earlier, focusing on UK consumers where you find competition problems, be open to remedies, don't diverge too much from international authorities. That allows the CMA to take that steer into account and then to say, when it faces the prospect of political interference on individual deals, hold on, no, back off. You've given me this steer. I'm taking into account. I now need to take the individual decisions independently. In some ways, that's going to be a bit harder for the Commission because the guidelines here, they ask the Commission to take into account quite a wide range of different policy issues. And rather than telling the Commission how to rank them, it emphasizes the discretion being given to the Commission. So it may be that member state governments and the presidency of the Commission allow DG Com to exercise that discretion, but it may be that they feel they do need to intervene more on individual cases. And I think when that happens, the really important thing is that influence is exercised transparently rather than behind the scenes, because I think where political influence is exercised behind the scenes, and where it is indeed for non-policy related factors, for where you see some of the allegations that have been made in the United States that friends of the president have benefited and had favors done to them, that's really damaging. And I think, before finishing on that point, one should say that the leaders of the US agencies very strongly rejected those allegations, and they have said that their decisions continue to be made independently of any external lobbying.
As you say, Stuart, it's made more difficult in the EU due to this at least now, currently mixed messaging from DG Comp itself, Ribera, and from other parts of the Commission, including not least the Commission President. So definite mixed messages there. It's probably relevant here just to ask you briefly as well. Brunswick, of course, a public affairs business. We're talking politicization here. Is your advice to clients, without giving away your secrets, of course, is your advice to clients on how to navigate this environment changing? Does it differ between the UK and EU? Obviously, companies and their advisors are going to have to think about efficiencies really early on, probably do even more work. But what else are you telling people?
So I think the starting point still has to be that merger reviews are going to revolve around sort of rigorous economic and legal analysis and putting your case effectively based on evidence to the authorities through the proper channels. There is no substitute for that. And I think any companies that are subject to a merger review will not get their deal cleared by trying to bypass that. So I think it's really important that is the starting point. I think the role of public affairs and political and stakeholder engagement in transactions, I think that is changing. I think, a few years ago, we might have thought that, well, so most deals aren't going to require any of that unless, say, you're looking at a 3-2, or it's a big consumer-facing kind of a company or companies that are reputationally challenged. I think what is changing now is that given that the guidelines do make clear that a wider set of policy issues can be taken into account, security, resilience, sustainability, and so on. What that means is there is a wider range of policymakers and stakeholders who are relevant to that and who may have opinions on the deal. And those opinions may be positive or they may be negative. And what we're increasingly finding is a couple of things. So first of all, companies wanting to do a bit more of what you might call that sort of political due diligence in the kind of early stages of deal planning, working out which issues, which people are going to be relevant in order that management teams and advisors can give boards sort of reassurance that they properly kick the tires on all of this and that there are going to be no surprises after they announce. So that happens more than it did in the past. I think the second thing is then the political and stakeholder engagement that you do during the course of a merger and ensuring that, that range of stakeholders who are relevant, who may opine, that you are in touch with, that you're making your case to, and you're providing kind of reassurances to throughout. But the third thing I'd say, and I think this is really kind of important, is that sort of the public affairs advisors and the legal advisors have to work kind of really closely together on this. So, for example, the theory of benefit that sets out that broad range of benefits of the deal, that will have to be kind of our focus as we're selling the case of the deal. So we have to work really closely together on that. And it's why I think, and appreciate I would say this, that it's important that you have, I think there's benefit in having some public affairs advisors who do actually have a proper background in competition, who are kind of sensitive to how DG Comp, to how the CMA kind of may feel. And certainly, when I'm working with my Brussels colleagues, I find it very valuable to be able to call on people like Jonathan Fall, Paul Chachard, who've been inside the Commission, like McGuireWoods, because it's really important that the case that we make is to our outside stakeholders is consistent with what you're saying to the competition authorities. And it's really important that what you're doing externally does not undermine your efforts to get the clearances from the competition authorities. What we can do is, I think, help make that case effectively and appropriately and take into account the broad range of other political and regulatory scrutiny that you might face. So that's not simply a question of other antitrust authorities. It's also, what's the impact of what you say on competition in Europe, on the FDI clearances that you might get from elsewhere, or on the political kind of risk that you might face in other jurisdictions. And I think bringing all that together is really.
Absolutely makes a lot of sense, Stuart. So finally here, what should we look out for next? I mentioned at the beginning, the consultation came out 30 April 2026. What are the next steps and what are you looking out for?
Yes, so the consultation closing at the end of June. They're hoping then to sort of publish sort of data guidelines by the end of the year, and that then they could be adopted sort of formally by the end of 2027. But significantly, the Commission has indicated that it would seek to take into account the content of the new guidelines in relevant cases, so before then. And so I think we should be looking at cases in significant sectors, of course, defense, tech, healthcare. And again, it's kind of striking that President von der Leyen, in that meeting of the College of Commissioners, specifically called out telecoms as a sector where she thought a change in approach was necessary and where there may be a case for more consolidation. So again, I think that's another sector where we should be paying particular attention to.
Draghi also called out telecoms from
Indeed.
memory as well. So great discussion, Stuart. Thank you very much. As you know, as a regular listener, we like to finish off our episodes with a bit of personal questions. So firstly, could you please tell us something interesting or unusual about yourself that we would not know from just working with you?
I am a teetotal wine enthusiast. I've been interested in wine for all of my adult life and probably a little bit of my non-adult life before then. And I gave up alcohol completely a couple of years ago as part of a health drive, but I still very much enjoy organizing tastings for friends. I still get a lot of pleasure out of choosing wine in restaurants and going through the wine list, but I don't drink any of it myself.
So you just taste it and you don't actually, if you like, properly enjoy it?
Exactly. So at tastings, you have to use the spittoon and try and avoid getting any red wine over my shirt.
All right. You can get a qualification, can't you, in that kind of thing, in wine tasting? Do you have any kind of formal qualifications, or you're an amateur?
Definitely an amateur.
Well, that's great. So finally, we're going to finish off here with our Curious Hat segment.
And now it's time for the Curious Hat.
So as a regular listener, you'll be familiar with this segment, and I've picked a question at random from our virtual hat. And the question is, do you like to cook? And if so, what's your favorite dish or your specialty?
I am hugely embarrassed that I am an appalling cook. So I don't cook very much at all. And when I do, I have two sons, aged 8 and 6, who have very, how shall I put it? Their tastes in food are very British and very childlike, so which is not conducive to imagination in cooking.
Well, I have two sons as well, 3.5 and 1.5. They're not British, but they have childlike appetites, so I can relate.
Well, thank you very much, Stuart. That was a great discussion. Thank you for coming on. I think we learned a lot. And thank you to our listeners. Until next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.